Good morning, everybody, and a very warm welcome to this morning's seminar, which focuses on the 10 things you need to get right when employing people. So before we start, we just want to introduce ourselves. I'm Victoria Templeton, one of the HR Knowledge Managers, and supporting me with the questions on the webinar today will be Sue Watson, Head of Client Services. And we also have a team out in the background who will be there to support with any technical issues. If you have any questions, then please raise them with us, and we'll go through them at the end of this morning's webinar. Because we have so many of you attending today, for obvious reasons, you're all on mute. That said, we do want to hear your questions. So please do so by noting your comments in the comments box as we go through. Here's a quick guide to show you how to do that. You can ask the questions via the GoToWebinar panel that should look something like this. Please type your question in the question pane and we'll aim to read out and answer as many as we can. We have just one poll today, which is right at the end. So when you do see this screen and a poll will appear, you just select the answer that is appropriate for you. Please note, to be able to participate in this poll, you'll need to ensure your screen is not in full screen mode, as for some reason it doesn't seem to work that well on GoToWebinar. And so now what we'll do is we'll focus on today's webinar, Employing People, 10 Things You Need to Get Right. So our agenda is going to look at these 10 areas of employment: contracts of employment, paying people, working time regulations, recruiting outside the UK, right to work checks, job descriptions and person specifications, essential policies, health and safety, pensions and employee benefits. So our first area to look at is contracts of employment. And in July 2017, the government commissioned Matthew Taylor to carry out an independent review of modern working practices. This review was called the Good Work Plan, and the principal aim of the review was that all work in the UK economy should be fair and decent, with realistic scope for development and fulfilment. When the review was concluded, the government accepted many of its recommendations, and we saw several of these being adopted into law in April last year. So when it comes to recruitment and contracts of employment, it now means that all workers have a right to have a written statement of employment. So whereas before this right was only for employees, the Good Work Plan extended this to cover workers. And a person is deemed to be a worker when they work under a contract whereby they undertake to do or perform personally any work or services for another party. They are free to accept or reject any offers of work made to them by other organisations. There is a legal requirement for an employee or worker to be given a written statement from day one of employment. And previously to this legislation coming in, employer had 2 months from the start date, but now it's from day one. It also brought in further requirements in terms of what information must be included in a written statement. So now it's a legal requirement for employees to include a breakdown of the hours and days of the week, whether the hours may be varied, and if so, how, plus any entitlements to any paid leave must be stipulated, as well as any other benefits not covered elsewhere. And finally, details of any probation period and training to be provided. We must also include in a written statement how holiday pay is calculated for those who work variable hours. And as a result of the Good Work Plan, we saw changes made to how this is calculated. So rather than using a reference period looking back over the previous 12 weeks, the reference period must now look back at the previous 52 weeks. And this should be made clear within the written statement. So moving on to number 2, which is paying people. So when it comes to paying employees, including those who are casual or on a temporary contract, as well as agency workers, they have a legal right to a minimum level of pay. What the level of pay will be will depend upon their age, and these rates are updated each April. So as you'll see here in the table, the rates of pay are correct as of obviously this year's increases that took effect a few weeks ago. You'll also notice the reference to both national minimum wage and the national living wage. Essentially, it's a different title based on the age of the employee. Both are still statutory requirements for how much you pay somebody. Another requirement around paying people is to, Another requirement around paying people is to pay statutory payments, subject to eligibility, of course. So this will be payments in respect of statutory sick pay, holiday, maternity adoption, paternity pay, parental leave pay, notice pay, where you're paying in lieu of notice, as well as redundancy payments. And just on a side note, organisations can currently claim 2 weeks SSP back from the government when SSP has had to be paid in respect of COVID-19. And another legal requirement is that your employees are entitled to itemised pay statements at or before the time any wages are to be paid. Now, this is crucial as it enables the employee to have sufficient information about their pay to understand how their net pay is being calculated. So the information that must be contained within a pay statement includes the gross and net pay, amounts of variable and relevant fixed deductions, the amount and method of payment where different parts of the net amount are paid in different ways, the total number of working hours, where the amount of wages varies by reference to time worked, and amounts of any fixed deductions. And finally, in order to comply with these statutory requirements, then it is important that you have a robust system in place to record the hours worked, the salaries paid, and to evidence that both the national minimum wage has been paid and the working time regulations have been complied with. And moving on to number 3, this is the working time regulations. And so the working time regulations are fundamental to the employment contract, as it sets out the rules on how you manage working hours, rest breaks, night workers, annual leave, and how these rules may alter depending on the employee's age and job role. It can be complex as there are many variables to think about, which I will shortly cover, but before I do, here are just some of the different elements of the regulations. So first of all, working time is restricted. There is a maximum weekly working time which must not be exceeded, and depending on the age will determine what that limit is. Working time does include job-related training, travel time as part of the job, which as a case ruling last year actually concluded travel and wait time of up to 60 minutes between client visits is also deemed working time. And it also includes working lunches and overtime. For those employees who may have multiple jobs, then where there is no opt-out agreement signed, each employer is responsible for ensuring that the total 48 hours are not exceeded. So we would recommend that employers include a provision in their contracts of employment requiring employees to obtain specific consent before taking on any additional outside employment. That way it can help businesses to know where there may be issues or potential issues with the maximum working week. And we should not forget that the main purpose of the working time regulations is to provide rest breaks for employees. So within the regulations, there are rules around statutory paid holiday. All employees and workers are entitled to 5.6 weeks paid annual leave each year, and those who are part-time will have entitlement that's prorated based on the number of working hours that they work. However, it's for an employer to define their holiday year and policy for how they manage annual leave. Now, I mentioned working time is a complex area. There are many variables such as age, role, industry, or what even is in the contract of employment. This table just highlights some of the different areas of the regulations that I've just mentioned. So it's highlighting the differences between the two age groups when it comes to a maximum weekly hours that can be worked. So as you'll see, we have a category for those of 18 years and above, and those above school leaving age but under 18 years. So for those over the age of 18, then the working hours must not exceed an average of 48 hours in each 7-day period. And to get the average, you look at the hours worked over a 17-week reference period. Now, this part of the regulation does not allow for an employee to opt out. So it allows for the employee to opt out. And where they do, there needs to be that written agreement in place and kept on file. So they can opt out of the 48 average weekly hours. For those above school leaving age and under 18 years, their week is limited to 40 hours. Now, it's these hours that cannot be averaged out, so there is no reference period, and nor can they opt out of that part of the working time regulations. In terms of daily rest breaks, these also differ depending on age. And as an employer, you can say when the employee takes rest breaks, but it has to be taken in one go in the middle of the day. So it can't be rest breaks taken at the start of the day or at the end of the working day. And they must be allowed to spend it away from the desk or workstation. And under the working time regulations, rest breaks are unpaid. Of course, unless the contract says otherwise, then obviously you'll need to pay. But essentially, under the regulations, they are unpaid. And then there are rest periods, which are different to breaks. So this is how long a rest, as a minimum, you must have away from the workplace between shifts or working days. So here you can see how this differs, again, depending on the two age groups. And night working is perhaps more complex, as there are several exceptions that can apply, and it will depend pretty much on what industry you operate in and the role of that the person undertakes. But there are distinctions, again, as I say, between these two age groups, as you can see. So moving on to number 4, we're going to look at recruiting outside of the UK. And we have seen a significant change to how we recruit since the UK left the European Union. And we've seen the introduction of a new points-based immigration system. So the implications of leaving the EU has meant the end of the free movement of people. And this is why recruitment has had to change. So from the 1st of January 2021, EU nationals wishing to live and work in the UK for the first time are required to apply to work in the UK through this new points-based immigration system. The visa schemes that were previously in place for recruiting non-EU nationals have been consolidated into this new points-based system, which will enable EU and non-EU nationals being treated equally in respect of coming to work in the UK. Under the new points-based system, the UK employer is required to hold a sponsor licence in order to recruit from the outside of the UK. So for those of you who may have recruited from outside the UK, non-EU nationals, then this won't be new to you. But if you typically have been recruiting from within EU, then this is going to be a change for you. And if you were employing EU nationals as at the 31st of December last year, and they want to continue working in the UK this year, then they have to apply to the EU settlement scheme. By doing so, they'll be granted either pre-settled or settled status. Now, they have until the 30th of June in which to apply. And what's really important to know is that it's something that they must decide. It's a personal choice. They cannot be required to do this by an employer. So to keep it simple, we can break it down into two groups. Those who were already in the UK as at the end of last year, and those who need to go through the EU settlement scheme, and those who were new to the UK from January onwards and who need a visa through the new points-based immigration system. The visas available under the points-based system include a skilled worker visa, and this is where they'll need to score 70 points, which will be gained through having either a job offer by an approved sponsor, the job is at the required skill level, and that they speak English at the required level. And then we have the intra-company transfers. So if you already have an employee working overseas, but you'd like to transfer them to work in your UK offices, then that employee will be able to apply for this visa. So they must already be an employee of the company, have 12 months experience working for a business overseas linked by ownership to the UK business, undertake a role at that required skill level and be paid at least £41,500 or the going rate for the job, whichever is the highest. Now, there are some exceptions to this particular visa where the salary is significantly higher, where in this case it means a 12 months experience won't be required, but we're talking when the salary is something like £70,000–£80,000. And it's likely that these two types of visas, your skilled worker route and the intra-company transfer, will be the main visa routes for working in the UK moving forward. Although there are several other visas that people can apply to work in the UK under, such as your global talent route, the international students and graduate visa, and startup and innovator visa. But we believe the skilled worker route and the intercompany transfer are going to be the main two moving forward. And this leads me nicely on to number 5 and return to right to work checks rather. So you'll already know that there's a legal duty on employees to prevent illegal working, and this is achieved through having correct right to work checks and processes in place so that all new hires confirm they are entitled to work in the UK. So at present, checks can be manual or online, and if it's a manual check, then a clear copy of the original documentation should be taken and retained by the employer with a record of the date the check was made. For an online check, a clear copy of the response provided by the online right to work checks must be retained by the employer with a record of the date the check was made. And in light of the pandemic, the Home Office made temporary emergency changes to the right to work checks, including these that essentially can now be carried out via video calls. Job applicants and existing workers can send scanned documents or a photo of documents for checks using email or a mobile app rather than sending originals. However, the Home Office updated their guidance yesterday, and they've now confirmed that these temporary adjustments that were put in place because of the pandemic will no longer continue from the 17th of May. This guidance that's been published, that if businesses also, the guidance that's been published talks about if businesses obviously are continuing to operate remotely. So obviously, how do you get around that? Well, therefore, they're saying that the person who you need to check will have to have their documents couried over so that you can then still carry out and verify their right to work. And once you've got those and are in receipt of the originals, then you would then need to verify their identity over video calls. So essentially, the change from the 17th of May is that you need to actually see the original documentation. An important thing to bear in mind is that right to work checks must be carried out on all employees and before they commence work. And as part of the transition to using a new points-based immigration system, there is actually a 6-month period in which employers will be able to continue to accept passports and national identity cards as part of their usual right to work checks. Now, this is in place until the 30th of June, after which EU nationals who do not have settled or pre-settled status will require a visa to work in the UK in the same way as non-EU nationals. So what happens after the 1st of July? In terms of right to work checks, well, we are waiting on guidance from the government to be published. All that we know is that they've committed to publishing it before the 30th of June. So as soon as that gets published, we'll of course provide relevant updates on our knowledge base and our website and let everybody know. But essentially, it is still unclear as to what is going to happen from the 1st of July, but we will find out very soon. And so now moving on to number 6 in regards to employment, and that focuses on job descriptions and person specifications. And there is sometimes confusion between the two. A job description, as the name indicates, describes the work which a job holder must carry out. It outlines tasks, duties and responsibilities, whereas the person specification describes characteristics, skills, abilities and experiences, etc., that the job holder needs to carry out the duties outlined in that job description. Job descriptions are vital not just for setting expectations, but also vital for supporting the appraisal system and ultimately being able to manage performance. In terms of the person specification, this is probably the most valuable tool in the whole of the recruitment and selection process, as it will form the basis of any advertisements which are drawn up. It will provide those doing the shortlisting with the criteria to screen applications, and it will enable interviewers to structure their interviews and decide who to select and who to reject. Of course, it also underpins any processes used in how you manage an employee performance too once employed. Now, where person specifications aren't used, employers risk discrimination claims because the selection of candidates may depend more on the likes and dislikes of individual interviewers. There is, of course, no legal requirement to have either of these documents. However, the benefits are massive to an organisation, and we would always advise that they are in place. And moving on to number 7, which is about essential policies. And when employing people, there needs to be in place well-written and communicated policies and procedures. Employees, workers and job applicants can all bring claims to an employment tribunal. And so having clearly laid out and well communicated policies can help in avoiding and defending claims. Not only can they help with this, but they can also provide guidance to your line managers. They enable you to implement your HR strategy. They ensure that your managers are acting consistently with all employees, which comes back to that first benefit about avoiding tribunal claims. And finally, they can help in the development of a fair and inclusive culture, as they bring transparency to the business in terms of how you manage your people. And therefore, it shows your workforce how they are to be treated and that it will be in the same consistent way. Now, in terms of the most important policies to have, we view the following 10 policies as being critical, even for small employers. So first of all, having an absence notification and sick pay policy, so everybody understands the rules in terms of phoning in, notification, reporting during absence, and obviously how sick pay is to be processed. Bullying and harassment is also critical, so setting out that you do not tolerate it, what defines bullying and harassment, and what steps people can take if they feel that they are being bullied or harassed. Family friendly are also very important. So this can either be one family friendly policy that deals with everything, or you can have individual policies, but they should be based around maternity, adoption, paternity, parental leave, shared parental leave, everything that's associated to family friendly. Then, of course, disciplinary. So it's really important to be able to set the rules and standards and expectations in your organisation, and having a disciplinary framework and policy in place sets that. So it tells people what's accepted, what's not, and what are the implications if they breach those rules and standards. And of course, disciplinary can both be informal in terms of informal file notes, or it could be formal, which can be various forms of warnings, including dismissal, whether that's procedural or gross misconduct. You then have, it's then important to have an equal opportunities policy. So it's setting out, your commitment to ensuring diversity and inclusivity in the workplace, and that equal opportunities will be given to all, regardless of age, sex, race, religion, etc. And then, of course, grievance. So everybody must be aware of what channels they have for raising concerns in regards to their employment. And it can be about anything to do with their employment, something that may be small to something that's quite complex and extremely serious, but there has to be a mechanism in place. And generally you find that there has to be an informal mechanism and a formal mechanism. So there should be some rules in place around how you deal with those concerns, so that people know that they are going to be treated fairly and what they should do if they need to have some resolution to an issue. And then, of course, health and safety. That's extremely important, and especially with COVID at the moment, there really needs to be a health and safety policy and that's accurate and reflective of your type of business. And performance standards. So it's going back to, if we think about the job description, person specs, that's setting out how you expect that job holder to perform their job, but what happens if they don't? And so where there are gaps in their performance, you would typically look to support them through managing their performance, through formal performance measures, before ultimately, if it doesn't improve, then you've got a formal performance framework in place in which you can manage that individual with the overall aim of improving performance. That's ultimately what you want to get. And then finally, the last two are about recruitment and selection. Again, this is about making sure that there's transparency and fairness in how we recruit, both internally and externally, and your approach to recruitment. And whistleblowing is extremely important, and it would be a separate policy typically to a grievance policy. People want to be able to know that they can raise protected disclosures if there's something of a serious concern in the workplace. So these are the 10 essential policies that we believe every organisation, including the very small employers, should have. Once in place, these policies need to be reviewed and updated to reflect changes in legislation, case law, and any changes within your organisation itself. And an annual update can also serve to keep the policies fresh in your employee minds. Now, if your HR policies are non-contractual, it is a relatively easy exercise to issue notice of any proposed changes and invite any comments or suggestions prior to implementation. So where possible, we would recommend having non-contractual policies. And now focusing on health and safety. So we have the Health and Safety at Work Act of 1974, and an employer's duty is to protect the health, safety and welfare, not just of their employees, but everybody who might be affected by their business. So contractors, agency workers, visitors, and the law also extends to employees who may be working from home. Obviously, we've seen an increase in that because of the pandemic. However, there are also other several pieces of health and safety legislation relevant to the workplace. So we have the Management of Health and Safety at Work Regulations of 1999, the Workplace Health and Safety and Welfare Regulations, Health and Safety First Aid Regulations, the Health and Safety Information for Employees, and the Corporate Manslaughter and Corporate Homicide Act. To name a few, not all, but these essentially your key main pieces of legislation. So from a practical perspective, and being compliant with all of the different pieces of legislation, we would advise having in place 5 steps to effective health and safety management. So first of all, have set policies. So if you employ 5 or more people, then there must be a written health and safety policy, although we would advise this being in place regardless of how many you employ. You want it to cover your general statement on health and safety, and so you can describe the organisation and detail your arrangements that you have in place for carrying the policy out. The policy must be brought to the attention of all employees and revised whenever appropriate. Bring any changes made to the attention of your workforce, especially at this particular time when we're returning to work during a pandemic. And secondly, it's important to organise staff. So there needs to be somebody responsible for the day-to-day implementation of the policy, but then have somebody more senior who has overall responsibility and accountability. And then ensure you have other additional staff, such as your first aiders, fire marshals. You might even have mental health first aiders as well. All staff, however, must know their health and safety responsibilities and where those responsibilities stop. And so but also who has authority over whom and in what circumstances. And it is a requirement under the Health and Safety at Work Act to provide training and to refresh that training periodically. Planning and setting standards is all about ensuring you identify the health and safety standards that are appropriate to your workplace and therefore the risks that are associated. And it's then about ensuring you can put plans in place to enforce those standards and ensure you maintain your duty to protect the health and safety and welfare of your employees and any other people that may be impacted by your business. Now, with any policy, it's important to measure its performance. So you will want to have measures in place to ensure that it's clear and easily understood, that it's working, and that it is also supporting the business in maintaining a safe workplace. This then can become part of the audit and review that you undertake. And finally, in regards to health and safety, I just wanted to finish this section picking on 3 particular hot topics in regards to health and safety and employing people. So your risk assessments, COVID-19, and mental health first aiders. So we know that under the Health and Safety at Work Act, employers have a duty to protect the health, safety, and welfare of employees and people who may be affected by their business. And so it's for this reason we must have a thorough risk assessment in place. Now, risk assessments involve ensuring that workers and others are protected from anything that may cause harm, controlling any risk to injury or health, and assessing those risks. Risk assessments are a mandatory task that all employers have a legal duty to complete. Written records of risk assessments must be kept where 5 or more people are employed, although again we advise that written records are kept even when you don't employ the 5 people. You know, they should be regardless of how many you employ. With COVID-19, we've seen a spotlight on risk assessments. The government, in consultation with professional bodies such as the HSE, as well as trade unions, have developed a set of documents for employers to help ensure their own workplace is COVID secure. And whilst we cannot entirely remove the risk of COVID, following these COVID secure measures, having a dedicated COVID risk assessment in place that's monitored and reviewed regularly will help to protect everyone and mitigate against risk. And finally, we know from the World Health Organization that depression is the biggest disability. We are seeing more and more mental health occurring as a result of COVID and lockdowns. And from a report published by the Health and Safety Executive last year, it showed that 828,000 workers suffered from work-related stress, depression or anxiety. 17.9 million working days were lost due to work-related stress, depression or anxiety, and 51% of work-related ill health was due to depression or anxiety. So it really is something that needs focus and attention and, to be on the agenda. And we would encourage having mental health first aiders within the business, because these can be a support mechanism for your staff. And these would be in addition to any first aiders. Now, they're not a legal requirement, but they are something that we are seeing more and more become common practice with organisations. And as I said, given the increase in depression and the statistics that we've just gone through, and on the back of a pandemic, we really need to put the health and well-being of our employees at the top of the agenda, especially in regards to mental health. Mental health first aiders can act as a go-between for those who are struggling, and they can look out for key signs and symptoms and actually know how to call for help when needed. And moving on to number 9, which is all about pensions. And all employers are legally required to offer a workplace pension scheme. And since 2012, on a gradual rolled out basis, organisations have been required to auto-enrol their employees into a pension scheme and make contributions where the employee is eligible. So there are several types of pension schemes, so I just want to summarise these. So first of all, the occupational pension schemes. So these are paid in addition to the state pension and offer tax relief on contributions, which are generally made by the employer as well as the employee. In addition, other benefits such as life assurance or pension for dependents in the event of a member's death are often offered as part of these schemes. They're generally managed by trustees or scheme managers, and if employee leaves the company, they are unable to transfer between employers, and contributions therefore cease upon leaving. Now, if the schemes are similar, then the funds can be transferred, but otherwise they are deferred until retirement. There are 2 types of occupational pension schemes: defined benefit, also known as final salary, which we're seeing less and less of. The pension is based on the number of years service in the scheme, and earnings may be an average of the latter. For example, an average of the highest or last 3 years salary. There are minimum funding requirements, and the employee is required to top up the fund as necessary. And then you have defined contribution, also known as money purchase schemes, based on the amount of money the employee and the employer have contributed to the scheme over the years, how that has all been invested and the return on the investment. Part or all of the fund may then be used by an annuity, which provides for a regular income for the rest of the member's life. And then secondly, there are group personal pension plans. So an employer can choose to provide access to a personal pension scheme and can also choose to make contributions to that scheme. The member may continue to pay into that scheme after leaving as well, and the money pot at retirement converts to an income for the employee. And finally, there are personal pensions. So these can be purchased from banks, building societies, or insurance companies. An individual contract will be in place between the pension provider and the members of staff. Members may normally only claim pension payments from the age of 55. There may be certain circumstances that allow employees to take their pension before, and the pension scheme provider will outline what a particular scheme allows. And the upper pension age at which all pensions must be taken is 75. And now moving on to number 10, employee benefits. So retaining your employees is going to be key for rebuilding your business following the pandemic. You're going to need stability and to have a workforce that's experienced and knowledgeable with the help of the business move forward. Now, as a result of COVID, we do expect benefits such as income protection, health insurance, life insurance, and even increased holidays to perhaps be more sought after by employees. And this has come through in research carried out last year. So rather than company cars, private medicals, health screening, I think it's simply people wanting more benefits that because of the psychological impact of COVID-19, you know, it's been so significant, and it's given people the last 12 months, you know, reminded them to think about the importance and need to safeguard their future and finances. And so we are suspecting that people's benefits that they desire are perhaps changing. Building a benefit offering that includes financial and non-financial benefits is likely to have a higher impact on morale, going to help retain your staff as well as attract candidates when recruiting, and therefore impact positively on employee engagement. So some examples of employee benefits include your health screening, private dental, company cars, buying and selling holidays, free refreshments at work, gym membership and life insurance. So consider reviewing and updating your benefit offering to retain your staff. Having an effective and desired reward package will be key. You could also consider having a flexible benefit system to tailor compensation packages to an individual, which would then enhance employee engagement even further. And so this brings me to the end of the top 10 things that you need to get right when employing people. So I hope you found that this has been informative and helpful. So just to summarise, it's focused on your contracts of employment and paying people, working time regulations, recruiting from outside the UK, and obviously the knock-on effect with the right to work checks, job descriptions and personal specifications, essential policies, health and safety, pension and benefits. So what I'd like to do now is to see if we've had any questions come through during the webinar, and check in with Sue if we've had them come through.
Hi Victoria, thank you for that. We've had just a few questions, mainly around the right to work checks that you talked about. So the first one is, will we have to carry out retrospective return to work checks from the 1st of July?
No. So there's not going to be a need to undertake those retrospective checks after the 1st of July for any European nationals who were in employment on or before the 30th of June. So, and I also understand employers will retain that statutory excuse if the initial right to work checks were undertaken in line with Home Office guidance. So no retrospective checking.
Brilliant, thank you. And with the new points-based system being in place, why do they allow the old right to work checks?
So this one's a bit of an oddity in that on the one hand, the new points-based system came into effect on the 1st of January, yet employers can continue to use the evidence as they have been doing in terms of verifying the right to work. I think this 6-month grace period is to basically help prepare employees to prepare, and it's almost to transition fully to the new scheme. So yes, the new scheme is in place. People coming into the UK should be going through that mechanism, but it's at the same time giving employers time to transition fully to it. But it does seem a bit of an odd one, but I think it is to help employers.
Okay, thank you. And is there any way you can find out if your employee has applied to the EU settlement scheme without it looking targeted?
No, and the thing to remember, and what I said earlier, is that this is a personal choice. It has to be made by the individual, and employers have no say in regards to that. So you have to be really careful about how you handle it. From my perspective, the best approach is, because what you don't want to do is face discrimination claims when you're singling people out. So the best approach is to perhaps, you know, send a generic company-wide message that says, for anybody that wishes to apply to the EU settlement scheme, we have lots of government material that you can refer to help in the process. Please follow the following links, because there's so much information out, and I'll put the links on the slides after the webinar. Because, as I say, you should not be singling people out and saying, are you going to do it? Have you done it? Have you heard? because that's targeted, I guess, harassment to that person, is ultimately a personal choice. And I think, you know, it is a personal choice because at the end of the day, you know, the whole leaving the EU was a UK-wide matter. It wasn't anything taken by, you know, anybody else. So just be careful.
Okay, thank you. And finally, if an employee doesn't have the right to work on the 1st of July, will you have to just dismiss them? I guess that's a bit risky, isn't it?
It is, and I think from what I've read, it's unlikely the government will expect businesses to terminate the employment as of the 1st of July. We are waiting new guidance to support new right to work checks for the period from the 1st of July onwards. There may be some indication within that, but from what I understand, it's unlikely they'll expect businesses to just do dismissals on that 1st of July. And also remember, we know there's no retrospective checks needed for those employed before 30th of June.
Yeah, and I guess you also have to understand, you know, first of all, have they applied? Are they waiting? Is there a delay? Do they have a Home Office letter giving reasons why it might be that, you know, they have registered, but that needs further investigation? You have to go through a few hoops before.
And also with COVID, I suspect that timescales for processing will be longer because obviously we've had, you know, all these restrictions in place from a work perspective. And also there could be a backlog. I know there was at Christmas time, you know, simply because people are wanting to apply for their pre-settled or settled status. So bear in mind timescales as well. It probably would take longer than it would normally.
Yeah, and we just got to hope that the government issue the guidance before the 30th of June to give everybody time to plan.
They have said they would, so let's wait. But as soon as anything comes out, we'll obviously put an update on our website and our knowledge base and clarify what that new guidance
what that looks like.
Yeah,
and possibly even run another webinar.
Yes.
So I think that's all the questions that I've got, and there's no more for me. So yeah, thank you, Victoria.
Brilliant, thank you. Okay, thanks, Sue, and thanks for the questions. So what I'd like to do is we're now at the end of the webinar, and I just want to run through a few final slides. And this one is a poll that I'd like to launch. And so if you would like us to follow up with you after this webinar, then please do let us know which of these following areas that you would like to be interested in finding out more about. So I'm just going to open the poll.
Yeah, just launch that for you.
Oh, you've done it. Thank you, Sue. So would you like to find out about our HR services, HR training, health and safety services and training, payroll and other? So do let us know if you feel you would like some further assistance from us.
Okay, just let that run just a
Thank
few
you.
more seconds. Okay, I'll close that now, but if anybody does want any more information and hasn't had a chance to register through the poll, just contact us. More information will follow shortly.
Thank you. Brilliant. So before we close, I just want to take the opportunity to run through our webinar schedule that we have in place until August. So we've got lots going on. We've got the next webinar on the 13th of May, which is all to do with how to deal with bullying and harassment. We then have the following week a coronavirus webinar. So I'll be running that with my colleague Dom. Dom will support from a health and safety perspective, and I'll obviously take you through from a HR perspective about how you can support that return to work after lockdown. We then have our June webinar, which is all about how serious allegations can be handled safely. And in July, we have a webinar that's what are protected or without prejudice conversations. And then with August, ending on remote working, how can you manage performance? Obviously, we're now seeing more and more working from home, and how can you manage performance effectively? And obviously, we'll keep adding to our webinars as and when relevant topics come up. And we'll keep you posted on those. So please do visit us at those links to register. It would be great to have you at those. And then we do also have some webinars in our diaries that we're partnering up with Norden's, an accounting firm, and it's all to do with the 7 key successes. So support for businesses. It's an interactive accelerator program. The first one ran yesterday, which was a really popular webinar, so you can now watch that on demand. And then we have ones coming up each week now, between now and June. So if any of those are of interest to you, then please register for those. We do have a number of training courses that we have scheduled in the diary, as you'll see on the screen here, covering predominantly HR as well as health and safety. So if any of these are things that you're interested in, then please do get in touch via the link on the slide. And of course, we offer free health and safety, HR, risk and compliance audits. So these tools are invaluable because it will allow you to carry out your own audit to ensure, are you prepared and have you got everything in place that you need from a Brexit perspective and people. There's a GDPR risk audit, a general HR risk audit, COVID-19 and a health and safety compliance. So do feel free to take a look at those, run through those audits, and you'll get a report instantly on the back of doing those to provide you with feedback on improvements. And finally, if you would like to stay in the loop and be amongst the first to be invited to any of our free HR and health and safety webinars, as well as receive our latest newsletter, then please do sign up via the link that's showing on the screen here. And of course, if you do have any further questions, then please contact us on the information and we'll be more than happy to help. And of course, as with all our webinars, we really do appreciate feedback. So we will be sending out a short survey to capture your feedback, and we really would appreciate it if you could complete this so that we can constantly improve our webinar program for you. And that ends today's webinar. So as always, I really want to thank you for attending. I know everybody is busy, but it's really good to have you join us, and I hope that you can join us in all our other future webinars. Thank you, everybody, and thank you, Sue, for the questions.
Thank you, Victoria.